well, we'll just call it the legal hotline. I get questions all the time, but I am going to borrow from none other than the actual MAR legal hotline today. So we're going to have some, I hope, ripe discussion. We'll have a little bit of fun with this. Matter of fact, we'll repeat this as we move in the future and see what this brings up. So if you're wondering, new background today, for all of this year, I've been in Troy and working with the guys down there, and coming to you from that location. As you're looking here, you're looking at the Clarkston office and what we've got going there. So Hot Topic Tuesday, don't be afraid to bring yourself off mute. Ask those questions. I'm kind of on my own today. I will give you a precursor for the next 2 weeks. If you know the name Karen Cage, Karen's going to be on with us next week. Karen Cage is our president, or CEO. She's the all-knowing, the one responsible for all things real comp. So Karen's going to be with us next week to talk about some of the changes that have come down through NAR and how that's going to affect the MLS. And for any Q&A that you guys might have regarding real comp itself and what's going on there. But with that, let's get kicked in and talk about today's hot topic. And again, it's just some legal issues. I'm going to throw out some questions, and I want you guys to kind of think about the answer and go, what do we have? And along with that, don't be afraid to ask any questions. You can go get lunch. I'm okay. It's going to be a little crazy because people are actually here. It's a wonderful thing. Here we go, guys. Question number 1. I am a licensed salesperson commonly known by the nickname Stevie M, and I use that name in all my advertising. Is it a violation of licensing to use a nickname in my advertising? No. Houston says you can't play yet. I want you to think about that. Matter of fact, oh yeah, check the chat room. I think that's a great place for us to be able to look and go. I'm going to wait. Let's get some commits out there. Don't be influenced. We'll see how everybody else does as they go. Yes, a non-licensed person can answer that question, even though she already knows the answer. All right. What is the correct answer? No. The occupational code does not prohibit. Now that's double negative, so yes, you can. A real estate salesperson can use name variation in his or her real estate advertising, so long as the use of such name is not done with an intent to defraud anyone. So otherwise, if you're not hiding who you are more than welcome to begin using a different name.
So if you notice Steve, right?
Oh, right. You got it. I'm going to leave that one alone, John. All right. Question number 2. I represent a buyer who has made an offer of $180,000. The listing agent called and told me that the sellers were rejecting the offer and the sellers would take no less than $170,000. And I'm looking again to make sure that we actually type this puppy up right. So yes, we did write that, right? Yeah, take a look, Andrew, just to make sure, because it really is a strange question when you get down to it from that extent. Hey, Luigi, we're on, but we sent you the correct link. Was that it? Yeah, there was a new one that I sent right before noon. I'm telling you, we're flying by the seat of our pants today, guys. So, but yes, it would be in. I did the all group, and I also sent it to the managers.
Luigi, I'll send it to you right now.
Send it to Roberta.
Roberta.
Yeah, they're right before noon. Okay. All right. I'm telling you, it's live. All right. So here we go. The listing agent called and told me that the sellers were rejecting the offer. The sellers would take no less than $170,000. My buyer then submitted an offer for $170,000, which the sellers promptly accepted. Although everyone in the transaction is happy, my broker believes that the listing agent breached the fiduciary duty owed to the sellers by telling them the bottom line price the sellers were to accept. Is my broker correct? So that's what we have to be wondering. So I got one question. Is the broker correct to number 2? Other thoughts? Go ahead and use this. We're going to have some fun. We'll create polls with the next time we do this. All right. You guys aren't going to cooperate that well with me, so here we go. The answer is potentially, yes, they are correct. Michigan case law has held that the broker representing a seller may not suggest to a purchaser that the seller will accept less than the stated price. However, are there circumstances in which we as a listing agent may be able to share that a seller would take less? And if so, what would that circumstance be? Again, you can take yourself off mute. So John actually got it here. If the seller gave permission for the agent to relay the information, we're good to go. Now, the big key is avoid verbal orders is something we've often heard, or as I've put it, AVO, avoid verbal orders. But Mr. Goings has nailed it in the chat room. If we got permission, we're good. Now, if they told us verbally, what is the evidence that we were told that? So avoid verbal orders. Get that in at least an email from the seller so that you've got something that you can lie back on if they ever decided they wanted to come after us. Next question. I'm representing a buyer in the purchase of a house. The listing agent said that by law, I'm required to provide them with a copy of the agency disclosure statement that I furnished to my buyer client. Is that true? So in short, are we by law required to give a copy of the agency disclosure given to our buyer client? Oh, we're more confident on this one. 2 yeses just popped up already. I'll wait. I'd like to see more of you guys. Put them in here. Let's share what your thinking is.
Sure, you should be jumping out short. Right? Just send it to the family.
Okay. Only 2 of you want to play and participate with it. Answer is yes, potentially. So the law is not going to require that we provide the listing agent with a copy of the agency disclosure that we signed with the buyer. But remember this, when it comes to disclosure, we are to disclose to all parties to the transaction as to whom we represent. So depending upon all the other paperwork, you may have to redisclose or sign something else with the seller disclosing that you have represented the buyer. So for some reason, we didn't want to provide the signed agency disclosure that we did with our buyer client, we'd have to sign another one with the seller with their signature, with a signature that the seller has that we represent the buyer. So what's the simplest thing for us to do? Just provide a copy of the agency disclosure. We do not have to provide the contract itself. And great, Holly, you actually hit it before I did. So absolutely right. So again, agency disclosure versus the agency contract or the buyer's contract. And we'll talk about that shortly also. Hey, for everybody coming in that didn't hear, my apologies in regards to the bad link that was sent out earlier. But remember this, if you will simply put Hot Topic Tuesdays into your calendar for every Tuesday at noon and copy the link that I sent to you late, if you were one of those who got blessed with my ineptitude there, save that in your calendar. You'll always be able to get into it because it is the same link for the entire year. All right. I think we're good there. We have a notice of buyer agency document, but no one seems to use it, but I do. Yeah, it really, I guess my thought is toward that. If we simply provide the copy of the agency disclosure, they've received what they need and should have and by the way, vice versa. We simply do need to make sure that all parties to the transaction are aware of who the licensees represent in the transaction. Number 4, is it true that an agency disclosure form is not required for commercial property? So this is those tricky questions. Look at the double negative, but is it true that we do not have to disclose on commercial property? And this is a good one. It's fairly common. We may be involved in some smaller commercial retail properties where it's real estate only. We'll call it simpler to handle. Otherwise, we do want to get a commercial agent involved. We need to do that from a point of the code of ethics, because it says when we lack expertise in the area that we will involve somebody in the transaction who does have the knowledge and expertise with that. Answer to this one is yes, it is true. Agency disclosure is not required. What it states is this, that it is required when it includes a 1 to 4 unit residential dwelling or a residential building site, vacant land. Note that some commercial property includes residential units, and disclosure would be required for those types of properties. So again, key, 1 to 4 unit residential dwellings. You must provide agency disclosure. Commercial, if there's no residential, no disclosure required. Question number 5. I represent someone who is interested in leasing a house. Am I required to provide an agency disclosure form? Again, put it out there. What do we think? We're getting some yeses. We're only getting, oh, come on. Limber up the fingers, you guys. I got another yes in the office here. And she's not even licensed, but she already knows the answers too. So, all right. So the answer is yes. It is, well, let's just read it. The agency disclosure law defines a real estate transaction as one involving the sale or lease of real estate consisting of not less than 1 or not more than 4 residential dwelling units or a building site for a residential unit. I think they're actually addressing more to the point of a condominium in that particular situation. But yes, it's a lease. It's not us who wants it. It is required by law. And I don't see any questions for that, so let's move on. Here we go. I am working in a designated agency office. Is it true? Oh, by the way, what is both our Century 21 and our Coldwell Banker? We both do practice designated agency. All right. I believe that somewhere in the near future, we may have a 30-minute Hot Topic Tuesday that will precede an actual agency class. But because you can't teach agency in 30 minutes to truly understand designated agency, it is simply this. The non-living broker, that non-living entity, says, I appoint Scott to represent you, Mr. and Mrs. Seller, and I appoint John to represent you, Mr. and Mrs. Buyer. Even though they're in the same office, it prevents us from having a dual agency situation like that. So now that we got that basic understanding to it, it says, I am working in a designated agency office or even a designated agency company like ours. Is it true that so long as I check buyer agency on the agency disclosure form, a buyer agency agreement is not necessary? Now, this is an interesting one, so hold tight to it. Again, as long as I check buyer agency on the agency disclosure form, a buyer agency contract or buyer agency agreement isn't necessary. So let's see what the thoughts come up with this one. I've got a couple of falses out there. Another false. I'm liking this. We're getting more and more participation. I've got a no. I think that you could get away without signing it. So what is the actual answer? No. And a matter of fact, it's an interesting twist. Under the law, unless the buyer signs a buyer agency agreement or contract, acknowledging his or her agent's designated agency status, the buyer will have an agency relationship with every other agent in the office in a company like ours, with everybody else under the gold or under the blue. So if you ever wonder why we are always asking, you need to get the buyer agency contract, it goes beyond just protecting ourselves, limiting the scope of our responsibility in regards to the search, limiting the fiduciary duties that we owe to them. It's hard to practice designated agency without it. So think of that one. And oh, by the way, we had a great discussion in Troy yesterday. This is just one more reason why we want to get that contract signed, but there should be a process that you use to get to the point to where we've earned the right for that buyer or to ask the buyer to sign a contract. Next question, number 7. I am an agent in an office that practices designated. I'm currently the designated agent for the seller. I also represent someone as a designated buyer agent. My buyer, pardon the typo, not bad, it's the first one. My buyer is interested in making an offer on my listing. So I have a listing, I have a buyer, both under contract. Buyer says, I want to buy this house that you have listed. Is it possible to be a dual agent in a designated agency office? And survey says, go ahead and type them in there. Yes, yes, dual, yes. Now we're getting some really confident answers here. They're popping right up, you guys. This one's pretty simple, isn't it? The answer is yes, absolutely. That is what we are able to do. It is possible. Scott, what was it? I would. He's been with me. It is possible to be a dual, not a double, but dual agency in a designated agency office. But you must get both the buyer and the seller to consent in writing. By the way, I use dictation on this part of it. Without informed consent, you have an unconsensual dual agency and will forfeit your right to a commission. Doesn't mean you won't get paid, but you forfeited your right to it because you did not redisclose the change in your agency relationship. So the answer is yes. And this is the most obvious situation where it is dual agency when you, the agent, represent both parties, the buyer and the seller, in the same transaction. Redisclose. Question number 8. I am a listing agent for a real estate firm that practices designated agency. That would be all of us. My husband works at the same firm, and he is the designated agent of a buyer who wants to make an offer on one of my listings. Can we do this, or are we required to enter into a dual agency agreement? Now, this is using a husband and wife, but could we not be using, let's say I'm working regularly with another agent, or I have a team, quote unquote, team member, two agents working together on the same team. Let's associate that being the same thing. So the question is, can we do that practice? Each one representing a separate party and not doing a dual agency. We'll throw it out there. Okay. Oh, you're fine. You can say that. We are in a group. We have more fun when we're live. Okay. So we've got some good stuff out there. This is a fun one. So here's the best answer for it. In reality, I just put 3 yellow dots there, and I should say, be cautious. It's the best thing that I can tell you. While the law does not expressly prohibit a husband and wife from acting as a designated agent or as designated agents on opposite sides of a transaction, we would strongly advise against it. If a problem later arises in connection with the transaction or the property, it may be difficult to convince the parties or a court that the parties receive the full range of fiduciary duties, and that coming from their respective designated agents. So I want you to just think about this. You work that closely together in the case of a husband and wife, you're living under the same roof. Can you truly keep those things separate and not talk, and then try to, if anything were to go wrong, and if it did go to the courts, not only could you not or have trouble convincing those parties to that transaction, but what about the judge who's going to judge whether or not you really did keep everything separate? So be careful on that one when it comes up. Talk to your manager is what I would tell you. I would give you my first inclination would be, if you're working together, you probably can't work separately. It would be very, very difficult to be able to do that. If you have a licensed assistant, I would tell you you're probably further ahead actually disclosing not only that you as the agent represent them, but that your licensed assistant also represents them. They are going to get confidential information. So that should be disclosed right up front on your agency disclosures. Number 9, I'm representing clients with a sale of their home. Oop, let me jump back because there was a question I missed. If they were a team, I would say it depends on how that team's operating. So, Holly, if you have a, what's the word, compartmentalized, where you have very specific listing agents, a very specific buyer agent, then I would say no. But typically your smaller teams where you've got 2, maybe 3 people on a team, then yeah, I would say that all members of that probably would be. But again, that would be talk to your managers and discuss with them as to what they would prefer that you do, knowing what this information is. So great question. Number 9, I am representing clients with the side or the sale of their home. I received a call from someone who was interested in making an offer on my client's home. So just, this is, I listed it and somebody comes along and inquires it, regardless of where it's at. If it's the internet, they walked in the door, or it was at an open house. They go, I want to buy it. The question here is, may I represent that potential buyer as a transaction coordinator? So I've got a listing, I represent the seller. Buyer comes along, says, hey, I want to buy that house. Scenario is this agent's going, should I do it as a transaction coordinator? Is that the best way to be able to do this? So what say you out there? It is 50-50 so far. We've got gray right in between, a yes and a no. We'll wait for you. What do you say? Yes, you can. I got a dual. We really do, John Lafferty, need to do an agency course. I want you to think about this, guys. If we simply talk about what a transaction coordinator is, there's that fence. Whoops. Stay. There's that fence. Transaction coordinator says you won't lean one side or the other. You already represent the seller. Which side are you required to lead or lean? Toward the seller. Transaction coordinator in this case really is impossible. You can't do it because you already represent the seller. So you're unable to represent a buyer as a transaction coordinator. So I'll read what's written here. While the law does not expressly prohibit, oops, wrong way. A transaction coordinator does not represent either party, but is a neutral party. You cannot be both a transaction coordinator and a listing agent in the same transaction. In these circumstances, you could work with the buyer as a customer, otherwise no agency relationship at all, rather than as a client. I'll tell you that I believe the best answer in this circumstance, with this person simply walking off the street, coming along and saying, hi, I want to buy the house. The best probably would be to disclose to them that you are the seller's agent. And I would simply sign a disclosure, check seller's agent, check off designated agency. I sign, buyer signs. They now know I represent the seller. I will throw out a quick one. How are we doing for time? Because I got one more for you guys. No, because your agency. So Scott asked, do I have to disclose that to the seller? The answer is no, because your agency relationship has not changed. So only upon a change do I need to notify the seller as to a change that my agency relationship has changed. But it stayed as a seller's agent, therefore I'm only disclosing to the buyer. And yes, as John put it here, because you already have a listing agreement with a contract with the seller. I'll throw this what if out there very quickly. What if this was a client of mine and they're selling their home? What might you want to do? Now represent them as a buyer. As a matter of fact, you should already had that signed. But again, when we do an agency class, we will hit that. And because we did get started a little bit late because I did send out a bad link for you. Here's question number 10. I am a real estate salesperson purchasing a home for myself. Can I act as a transaction coordinator in this purchase? So as Scott just put it, well, based on what you just said, I think there becomes a pretty obvious answer. You cannot. Look, are you really going to represent somebody else? Are you not going to represent yourself? You cannot be neutral in representing yourself. Again, so understanding what a transaction coordinator, you can't be it. It's a neutral position, and you are not going to be neutral on yourself. You've got things that the other party does not have. Yeah, I am biased upon myself. While the law does not expressly prohibit a husband, whoop, why did it go the wrong way again? I don't know. I think it's just acting funny on me. So the bottom line is just like the previous one. You can't not represent yourself or be a neutral party when you're involved in it. So, gang, I hope you enjoyed today. I will let you know again, Karen Cage is with us next Tuesday. All of these are at Tuesday. So if we ever send you another one that says it's at 12:30, I apologize in advance for that. If I ever send you a bad link again, I apologize. But again, just be reminded, the link that you got and the one that you logged in today, put it in your calendar every Tuesday. We'll let you know in advance, and we're not going to have one as much as possible. But every Tuesday at noon is Hot Topic Tuesday. Next week, Karen Cage, the supreme leader for RealComp, will be with us, discussing the changes that have come down from NAR and how those rules affect us in the MLS. The following week, believe it or not, we already have it. It's a hot topic, and we want to talk about the market. Guess who's coming?
Who?
Chris Hendricks. So Chris is going to be our primary speaker in 2 weeks. So next week, Karen Cage, week after that, Mr. Chris Hendricks himself. And you guys have a fantastic, you got ideas as to what the next hot topic should be, drop a letter to me. You guys have a great one. We'll see you next week. Bye-bye.